All right, let's talk about the costs, both financial and otherwise, associated with the death penalty. So, this is a topic that isn't really considered all that much when we debate the death penalty. And some say, why should the taxpayer board and feed these evil creatures for life? But a capital case actually costs far more than a life without parole case. It also takes more time to process and prolongs the suffering of victims who see execution as a form of closure. The ladder from crime to the gallows is costly, very tall, and ever expanding. Preferment was cheap, short, and swiftly climbed. Walter Williams was arrested 12 days after his crime and executed 33 days later in 1934. The cost was roughly $4,000, which would equate to about $71,000 in 2014. Today, as in the case with Charles Ng, it could take 24 years and $11 million. So the trial of Timothy McVeigh was even more costly. On April 19th, 1995, McVeigh detonated a massive bomb that destroyed the Alfred P. Maurer Federal Building in Oklahoma City. He killed 168 people and injured 680 others. And he was arrested just 90 minutes later when he was stopped by a trooper for driving without a license plate. They discovered he was carrying an unlawful weapon. Forensic evidence then linked him to the bombing, and he never really denied his guilt. He wanted a trial so that he could present a necessity defense. This would basically give him a soapbox to air his grievances against the federal government, and he was particularly upset about the incidents at Ruby Ridge and Waco. His attorneys did not argue a necessity defense because it would require them to prove the government has placed McVeigh in imminent danger. So instead, they decided to paint him as a patsy in a larger conspiracy, arguing that the bombing was far too complex for him to have conceived and carried out alone. Now, jury selection took 3 weeks, and the jury took 23 hours to deliberate and return a guilty verdict on 11 counts of murder. The jury deliberated for 2 days and came back with a sentence of death, and he was executed in 2001. The trial cost $13.8 million, over $6 million for 19 lawyers, $3 million for defense experts, $1.5 million for support staff for attorneys, $1.5 million for housing and security, $2 million for investigators, and a little over $500,000 in travel expenses. Now, this case gave the impetus for the Anti-Terrorism and Effective Death Penalty Act, which is supposed to make the death penalty more rapid, efficient, and less costly. So it's difficult to assess the cost because there's no standardized data across states that allows us to really make comparisons. Now, our text compares California, which has the largest population and largest number of convicts on death row, with Texas. California reluctantly imposes the death penalty, while Texas rigorously imposes it. And Texas executes more people per year than California. So California has 743 death row inmates, and that costs about $11.5 million per execution. Texas has 276 at a cost of about $5.08 million per execution. And much of that cost difference results from speedier and more efficient processing of death penalty cases in Texas. And here you can see a breakdown of the California death penalty study and what some of these costs are. Now, going back to the Ng case, had California sought life without parole, Canada would not have fought extradition, and they would have saved costs of multiple legal suits and costs. Federal District Court Judge Cormac Carney vacated the death sentences of Ernest Jones and 747 other California death row inmates. In his ruling, he noted that of the 900 people were sentenced to death in California since Gregg, only 13 people were actually executed, and the last one was executed in 2006. Each execution would have cost $308 million. And Carney noted the very delays caused by the system for the defendant's benefit create uncertainty in the mind of the defendant as to when he or she will be executed. And Carney says this constitutes cruel and unusual punishment. Furthermore, because execution occurs so long after the crime, it serves neither retributive nor deterrent purposes. Now, Death Penalty Information Center notes that If the sentences of all prisoners on California death row were commuted to life without parole, it would save $130 million per year. And the ACLU notes there is a $1.1 million difference between the least expensive death penalty prosecution and trial and the most expensive non-death penalty murder prosecution and trial. So what we are paying for at such great cost is essentially our own ambivalence about capital punishment. Now, some argue that the costs of the death penalty are inflated. So, for example, the costs per year of incarceration are typically calculated by dividing the total cost of running the prison system by the number of inmates. But those in LWOP are housed in more secure areas and have much higher total costs. And death row also requires more secure units and possibly the same medical costs. So those particular inmates may cost more than your other typical inmate. Now, one of the biggest cost differences is the number of court dates. So in terms of pretrial motions and hearings, capital cases take about 85 days, whereas LWOP cases take 14. In terms of the voir dire process, capital cases take 26 days, while LWOP cases take 1.5. In terms of trial, a capital case averages 19 days and 21 days for sentencing, whereas an LWOP case averages 8.2 days and sentencing takes less than a day. In total, capital cases average 147 days, while LWOP cases average 24 days. Now, there's obviously additional costs involved in further investigating the crime. So, in terms of preparing for trial and post-trial appeals, and an investigation of a murder can take as long as the case is actively under appeal. Defense has the right to raise any amount of exculpatory or mitigating evidence that then the prosecution has to investigate and defend. And they can also hire private investigators who may charge up to $200 per hour. Now, another cost here is that of expert witnesses. They can command fees many times greater than they would under market principles. So one legal scholar spent 6 years investigating discriminatory processes in capital cases and presented to the state of Connecticut a bill for $3.5 million. Now, the state only paid $1.75 million. In 2012, the federal trial of Brian Richardson highlights the high cost of expert witnesses. Now, this man was already serving life for a series of armed robberies when he murdered his cellmate. The U.S. Attorney's Office assigned 8 prosecutors, which they flew in and paid fees to and expenses for victims of crimes committed years beforehand. They appointed 20 private attorneys at $120 per hour to represent inmates who testified against him. It was a 4-year-long prosecution, a 9-week trial, and it cost us $3.5 million. He ended up with life without parole, which he was already serving. Expert witnesses in this case, they paid $150,000 to mental health experts who were ultimately prevented from testifying, and other expenses came to $200,000. Now, Richardson had been willing to plead guilty for life without parole from day one. Now, habeas corpus is Latin for you have the body. It's a civil law process that challenges the legality of a person's confinement and is a court order requiring that an arrested person be brought before a judge to determine the legality of his or her detention. And at this point, the judge could order the person free. This doesn't mean they're innocent. It simply means that the grounds to hold them is not sufficient. Now, this is formally codified into English common law by the Habeas Corpus Act of 1679, and it's only one of 3 individual rights mentioned in the Constitution. So a habeas corpus petition is a civil action against a state agent, usually the warden, and it's an indirect appeal challenging the legal grounds for holding someone in custody. The defendant can make any number of claims and introduce new evidence and arguments. Now, habeas claims filed in state court usually pertain to some legal error, and the petitioner is not restricted to the trial record. For a direct appeal, you are limited to issues raised in the criminal trial. This asks an appellate court to review the legal procedures and decisions made prior to the judgment of guilt and does not allow for introduction of new arguments or evidence. So habeas petitions filed in federal court to appeal a state conviction often involve layers of additional complications because of the Anti-Terrorism and Effective Death Penalty Act. So this act has broad bipartisan support and was signed into law in 1996 by President Clinton. And two primary events led to this passage. One is the crime control-oriented Republican Party majority in the House and Senate, and the second is the Oklahoma City bombing, which came on the heels of the first World Trade Center bombing, which happened in 1993. So the American public was growing tired of the interminable appeals filed. And the goals of the AEDPA were to deter terrorism, provide justice for victims, and provide for an effective death penalty. Prior to the AEDPA, there was no statute of limitations on filings and no limit to their number. There was no requirement that all these claims be consolidated into one appeal, and so death rows across the country were increasingly and rapidly becoming deadlocked. Under the AEDPA, there is a strict one-year statute of limitations, and you can no longer file successive petitions unless a federal court of appeals says you can. So habeas relief is only available if a state court's ruling is deemed contrary to or unreasonably applied to established federal laws determined by the Supreme Court. So basically now you have one shot at habeas relief, and all your relevant appeals must be consolidated into that one petition. The average time from sentencing to execution has increased by more than 5 years since the passage of AEDPA. So even though this is supposed to make the death penalty more efficient, it actually hasn't. And the Supreme Court has upheld the constitutionality of this law on more than one occasion. So basically, the language of the statute has led to numerous interpretive splits in different federal appeals. The act was also not automatically applied to the 50 states. They had to meet certain criteria in order to qualify, and so they have to establish certain mechanisms and adhere to standards and procedures that shift the financial burden from the federal government to the states. So states have to provide fully competent and adequately compensated counsel in order to use AEDPA's reforms, and no state has done so. Attorneys who meet these strict requirements are really hard to find. They have to have represented defendants in at least 7 felony appeals, including a murder appeal, or completed 5 appeals, including 2 death penalty appeals. And then they're compensated at $140 to $163 an hour in California, whereas if they're engaging in civil litigation, they could be making, 2 to 3 to 4 times that amount. Now, the most common complaint of crime victims and their families is that they're practically ignored by the system, except for the day of execution. Close family members of the victim are typically invited to attend, and victim and offender family members are often eagerly sought out by the press for comments. Now, comments are remarkably diverse, but the most frequently expressed sentiment is closure, whereas others focus on a desire to see that justice has been done.